Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the attorney work product doctrine. And the reason why there's a shield here is because the attorney work product doctrine is a shield that protects information from discovery. So let's go ahead and jump into it. We'll start with the seminal case on the attorney work product doctrine. This case is Hickman v. Taylor. This case was heard by the Supreme Court of the United States in the year 1947. So the fact setting is pretty simple. There's a tugboat that sank, and the plaintiffs are suing the tugboat operators for damages. Now the defendant's attorneys were served some interrogatories. Interrogatories are basically questions that parties can send to one another. They have to answer back written and under oath. There was one of these questions that the defendants refused to answer. That question essentially sought to discover any information from interviews between the defendant's attorney and tugboat crew members. So any informal interviews that have been conducted between the defendant's attorney and the crew members. That's what they sought to discover via that interrogatory. And this question went all the way up to the Supreme Court. Is that information discoverable or is it barred? Ultimately, the Supreme Court held that the interviews were protected by the attorney work product doctrine and that another party could not discover them. Now, they cite to Rule 26 of the Federal Rules of Civil Procedure, which we will dissect more thoroughly in the next slide. But essentially, Rule 26 protects product that is created by attorneys in anticipation of litigation. So if you can prove that something was produced in anticipation of litigation and you're an attorney, then that will be protected. Another party can't discover that information. And that's the general gist of the attorney work product doctrine. So there's a quote from the majority opinion which reads, "When Rule 26 and other discovery rules were adopted, this court and the members of the bar in general certainly did not believe or contemplate that all the files and mental processes of lawyers were thereby opened to the free scrutiny of their adversaries." So that's a little bit of the reason for this doctrine. Justice Jackson, in the same case, writes a lengthy concurrence, and I think he dissects it a little bit more clearly than the majority even does. And he has a nice quote that will just basically illuminate the reason for this rule here. What Justice Jackson says is, "I can conceive of no practice more demoralizing to the bar than to require a lawyer to write out and deliver to his adversary an account of what witnesses have told him. Even if his recollection were perfect, the statements would be his language permeated with his inferences. Everyone who has tried it knows that it is almost impossible so fairly to record the expressions and emphasis of a witness that when he testifies in the environment of the court and under the influence of the leading question, there will not be departures in some respects." And so you can see Justice Jackson's main concern here is that, well, we don't really want attorneys' notes and internal memos and those things to be discovered. Well, because there's always going to be a bit of the attorney's thought process in those memos. An attorney's not simply just going to make a script of everything the witness told him. Well, he's going to have some notes there. He's going to say, well, this might lead into this legal theory, or that might lead into that legal theory. And for that reason, if we were to just give plaintiffs or even defendants access to attorney work product, you would essentially be able to see the attorney's whole thought process on full display. And that's not fair, is what the court is thinking here. And furthermore, they just don't want attorneys to be witnesses. It's not proper for an attorney to get called to the stand, right? If an attorney's work product is discovered, then there's a chance they might have to be called to the stand as a witness, and that's just something that the court doesn't want attorneys to have to do, and something that attorneys don't want to have to do as well. So here it is, Federal Rule of Civil Procedure 26b3. It's called trial preparation. The main gist of this rule, like I said earlier, is if there's documents or tangible things that are prepared in anticipation of litigation, those materials should not be discovered, right? There's a general rule that those things are not discoverable. But there's an exception, and this exception is important. That is AII, and it says if the party shows that it has a substantial need for the materials to prepare its case and cannot, without undue hardship, obtain their substantial equivalent by other means. So that's the exception, right? So the attorney work product generally protects everything, but there is a small and narrow exception to that if there's a substantial need and there's undue hardship. Okay, so what does that look like? Here's an example. Substantial need and undue hardship. So let's say that a man dies during open heart surgery, tragically. So the plaintiffs are starting to think, hey, let's file a wrongful death claim against the doctor. Something went really wrong in this open heart surgery. Now, the defendants, the medical malpractice insurance, is beginning to think, hey, a claim might be coming our way. And so they conduct this interview, just an informal interview. This isn't a deposition. This is just an informal interview where the defense counsel for the medical malpractice insurance company talks to this open heart expert, and he gets some notes from him about basically what needs to go on in this open heart surgery for it to be proper. Okay, now shortly after the defense attorney gets that information, let's say that open heart surgeon dies, right? He just dies of natural causes. There's nothing nefarious going on there. Well, then, is there a substantial need and undue hardship for that information from that interview between the defense attorney and that open heart surgery, or that open heart surgeon? And the answer is almost certainly no. That information, that interview, the notes that the attorney took there are almost certainly not discoverable because the plaintiff could get similar facts from another open heart surgeon, right? The open heart surgeon that the defense attorney interviewed is not the only open heart surgeon on the planet. There's plenty of these people out there that exist and that could be, interviewed or deposed later in the litigation. So there's probably not a substantial need here for that interview and for the information that the attorney prepared during that interview. All right, so let's look at scenario 2. Let's say, same scenario, wrongful death action, open heart surgery. The attorney interviews an expert open heart surgeon, but let's say that this expert open heart surgeon was the only expert open heart surgeon that really knew the particulars of this type of open heart surgery. There was really only this one other guy. There's the person who did the surgery and the other surgeon that is the expert, right? So there's just these two on the planet. The defense attorney interviews the other open heart surgeon, essentially the expert, informally, and that open heart surgeon dies naturally again. Well, here, there's a much better argument that information from that expert open heart surgeon that was the only other person aware of this type of surgery on the planet. This is a hypothetical, it's a stretch, but I'm trying to show you how narrow the exception really is. There's a chance there that, the court's going to say, there's a substantial need here for this information, and there's an undue hardship to place upon the plaintiff here to try and figure out where another expert could be, or to try and go through this expert's old notes or figure something out like that. So hey, here we're going to allow this narrow exception to the attorney work product doctrine and allow the plaintiff to discover this information. So that's the video. Just in sum, to review, the attorney work product doctrine protects information in an attorney's file, right? So memos, interview notes, things like this from discovery by the adversary, so long as they are prepared in anticipation of pending litigation. That's the key. And so thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.